So thank you, Professor Patwardhan, for giving this nice introduction. Very good afternoon to all of you. And myself, Sanjana Mitra, I am working in Industrial Research and Consultancy Center in IIT Bombay. Our department is actually facilitating all the techno-administrative activities related to IP, means intellectual property filing, its protection, its maintenance, and its commercialization activity. So for the next 1 hour, I will give a brief introduction to intellectual properties and overview of what are the intellectual property rights, means a right related to intellectual property, and how to manage IP, means intellectual property, in an academic institute. So the very first question that comes to our mind in this particular area is, what is an intellectual property? As the name implies, it is a form of property and it is the outcome of human intellect, the creation of mind. Like in otherly commonly understandable property, it has some value, some asset, but once the ownership of that property gets registered, and suppose I have bought a piece of land. When that needs to be registered to my name, I need to give some declaration to the governing body of what are the inside that land. Suppose it may include some water body or some construction like that, and I need to define the boundary, outside boundary of that land. On declaration of that, that governing body gives me the ownership of that land. Similarly here, when we disclose our intellectual property to the statute, to the government offers us rights to protect that ownership of the IP. That is called intellectual property right. But there are some difference between the commonly understandable properties and intellectual properties. Intellectual properties are the intangible form of property. It is a virtual form, something concept, something idea. But anything virtual cannot be protected. So the first step you need to take is that you have to reduce that idea into some practice. Means it needs to transform that into some tangible form. Like if I have some creative idea, the expression of that creative idea can be protected by copyright. If I have some technical concept, I need to make some invention out of that, and that invention gets protection through patent right. Similarly, the aesthetic appearance of an article or device can be protected by design art. And if I take some effort to establish some distinguishable, identifiable quality of my product or my brand, it can be protected by trademark. And if I have something that is not that much unique or that much novelty it has, but it is very useful for my further R&D work or my institution, so then that can also be protected by simply keeping it confidential. Nothing disclosure needs to be done for that, and it should be protected by trade secret. So why to protect an IP? First of all, as I mentioned there, that I need to disclose my IP to the statute, so that statute will offers me the right to protect that. What if I don't protect that? So there is always a chance to be stolen, to be copied my invention, because it can be anyone can copy that from the public disclosure and all these things, and I have no right to stop them unless I protect it. And when I get the protection, I have the monopolistic right to exclude others in making, selling or using my IP without my authorization. So that is a reward system what I can get by protecting my IP. And of course, it encourages innovation, because new technologies are coming up, and once I get a protection, get the monopolistic right out of that protection, so it gives me the monetary benefit also, and it helps in further research and development. And when I disclose my IP to the statute after some specified time period, they will disclose in the public domain. So anybody working in that particular field, particular technical area, they also know what are actually going on in that particular technical field. So it is easier for them to avoid the reinventing the same thing. What is already available, there is no meaning to reinvent the same thing. So you can avoid the wasting of money, time, efforts, all of this. And of course, most of the market leaders of any particular technical field, like in case of mobile technology and all this, what they are doing, they are always offering alternate solution to the technical problem. So society also get benefited because they are getting continuously new technologies, alternate technologies, and that is why the price of that thing actually under control, can be under control. And also, if any institute or any industry have a very good IP asset in a particular field, it increases its market value to earn more and more incentives from the investors or in getting any government fund like that. So now let us see what are the role of IP in academic institutes. Academic institutes are mostly involved in teaching, in creation of scientific knowledge, ideas, but all these things means whenever you lead to research and all these things, so we need some trained, skilled manpower, some resources, some funding, some infrastructure. So all are not actually comes into free. If our institution have a good intellectual property asset, so we can monetize them, we can license them to the industry and get a good investment for our future R&D work. And also it helps in getting better national ranking, so that government funds also come to our institution. Now let us talk about what are the rights, what are the types of intellectual property rights. So we can broadly classify intellectual property rights in two ways. One is for protecting the artistic or any creative work, that is under copyrights, and other one are which have some industrial applicability. The invention, if there is any technical invention, as I have mentioned, it comes under patent right. If it is an appearance of an article, it is a design act. And there are other types of intellectual properties which maybe trademarks are also related to this, but GI and new plant varieties and all these things are that much not relevant to our. Hello? I will come on this later, sir. I will briefly explain all these things in my later slide. To protect the intellectual property, we have some legal framework. For each type of intellectual property, we have some criteria for protection. Like for patent, for any invention, novel invention, we need to get a patent protection. And to get a patent protection, we have three statutory criteria. One is novelty, one is inventiveness, and other is industrial applicability. I will explain this when I discuss about patent rights. And there are some terms of validity, period of validity. This monopolistic right, whatever the statute offers to inventor, to the owner, it's for some certain period. It's not lifelong. Just like in case of patent, it is 20 years. All these intellectual property rights are territorial right. Nothing is called global patent, global copyright or like that. If you are filing in India, you are seeking protection for your invention in India, that means your invention is protected only within the India. Anybody can outside India can use your invention if you not seek protection outside, means wherever you are actually interested for. And you have the ability, it gives the ability, the owner to license or transfer their technology, their protected IP, and you can also suit infringement to the others who are actually trespassing. We are actually unauthorizedly using your IP. As I mentioned, there is a legal framework. So we have some international framework too. One is governed by World Trade Organization, WTO, 1977. It actually helps in governing trade-related aspects of intellectual property rights. Whenever you have IP and you are you're doing some commercialization cross-border, means across your country and all these things, this governing body is actually administers. It helps in harmonizing the intellectual property rights laws in different countries also. In this case, India has become party of this WTO in 1999, and it has made a major amendment in Indian Patent Act in 2005. I'll come to this in later period. The second one is World Intellectual Property Organization. This is also established in 1967 in Geneva. They administer all the international treaties related to IP protection, and they also do many workshops, courses, so that people get aware about this IP and its protection. They help in harmonizing intellectual property laws across all the countries. As I mentioned, in case of WTO also, they are also helping in the same way. Like earlier in US, the patent application was valid for, patent protection is valid for 14 years. But now, all over the world, it is the same for 20 years. Now let us see what are the legal framework in protection of IP in India. The first one is Patent Act 1970, and which is, I have just mentioned that as per the WTO obligation, India has made some major amendment in 2005 in the field of pharmaceutical, food and chemical related patents. Earlier 2005, India has allowed only the process patent of this particular technical field. No product patent was allowed in that time, but as per the TRIPS agreement governed by WTO, India has now started allowing, after 2005, it has started allowing all the product patents in this particular field. Then the Copyright Act, just like in 1957, Design Act, all these particular intellectual property rights are protected by or legal, there are some legal rules and acts to establish the criteria for protection, validity and all these things. So now let us discuss about what are the patent rights. Patent rights are exclusive right granted by the government to the owner to exclude others, to refrain others to make, sell, use of your invention for a specific period. As I said, it is for 20 years and in a particular jurisdiction where you have sought the protection. And this is given for innovative products, process or a composition of matters while fulfilling the following criteria. One is the novelty. It is the uniqueness, the new thing in your invention that should not be present in the existing knowledge of the particular technical field. And the second one is non-obviousness, that is the inventive step. Means your invention should not be deduced by any person having ordinary skill in that particular field. I am giving an example, like in 2001, one British inventor has a invention and granted patent on pedal and powering an eco-friendly way of charging your mobile phone. So, as we all know, the pedaling is for just moving or for bicycling, but he has, it is a simple concept, but nobody has think of that. That kinematic energy that is developed due to the pedaling of the bicycle, he just transformed it into some electrical energy, and that is actually in helping the aid to charging a mobile phone. So he granted that, got the grant of that patent in 2001. And every invention must have some industrial applicability. If it is a process, then that process should be industrially reproducible. If it is a product, that product can be made, can be manufactured in industry. Most people think that the patented inventions are coming from great scientists, from big industrial R&Ds and all these things. But statistics says most of the patented inventions are coming out from the engineering institutes. Engineers are the most commonly widely accepted inventors of patented inventions. Just like for some examples, it is a Velcro tape, and some Swiss engineer, he has developed this Velcro tape out of the just natural incident what he has faced while doing morning walk. So what has happened that some seeds are stuck to the fur of his dog. So he just closely look into that, investigate that matter, and he finds there are some hook-like structure into the seed. So he has developed this Velcro tape. This is a two-part nylon tape. One has a small, tiny hook-type structure, and the other one has a tiny loop-type structure, so that it can get fastened. And it is patented in 1951 by Velcro company. Similarly, we have a flat-bottom paper bag. It is invented by Margaret Knight in 1867. And that James paper clip, this is used for hold together papers and all. So it is patented in 1817. The interesting story is whatever the modern James paper clip we are using, that is manufactured by James company, and they are not never they have patented it, because at that time in that era actually that public disclosure of patents was not that much, because online digitalization was not there. So in 1870, the James company has first time they introduced the James clip in the market, but they are not aware in the same year US government has signed some patents to some US inventor. Similarly, we have some even that invention should not have always a new thing out of the basket thing. It can be some incremental invention also. Whatever the problem exists in the prior art, in the prior knowledge of this particular technical domain, you can solve this also. So like we have in 1980s, we have this floppy disk for external memory storage device. Now then it will move to CD optical disk in 90s, and finally we have now this USB stick. It is all the purpose of these things are same, but they have introduced some more advantageous things. It is more robust in nature, it is more tiny in nature, so it is more easy to carry out, and storage space is also increasing. Now let us see what type of inventions are not covered by patent rights. As per Indian Patent Act, there are some frivolous inventions that is contrary to natural law. Like if you just claim that I have made a device which is actually giving more than 100% output, this is not patentable. Then if something you have developed, that is the use of that thing actually contrary to public health, order or morality, that cannot be patentable. Like the gambling machine, something explosive you have developed, but that are not patentable inventions. Then if you have discovered some scientific principle, theory, the basic core fundamental research doesn't lead to patented invention, because it doesn't have direct industrial applicability, utility. So for this core research you can get a Nobel Prize, but getting a patent is of course difficult. So and for any invention that is related to some living or non-living substance that is available in nature, cannot be patentable. New form of known substance, new property of a known substance cannot be patentable. And of course traditional knowledge. So one interesting story I can share with you. There was a US granted patent on the antiseptic property of neem. Afterwards, CSIR from India, they have opposed this patent, citing the reason that antiseptic quality of neem is we are using in India from ancient age. So it is known to us. So India is the only country who have the digital library of traditional knowledge, and anybody can access throughout from anywhere from the world, and this traditional knowledge, concept in this traditional knowledge cannot be patented. Any method of agriculture, horticulture, then process for medical and diagnostic treatment method cannot be patented. You can patent a device for treating the things or any device for getting more and more diagnostic helpfulness and all these things, but the process of treatment cannot be patented. Any mathematical business method, computer softwares in India are not patentable. So, what are the due diligence we should follow before filing for a patent application? We must see that our research output satisfy the legislative criteria, as I have mentioned, that 3 legislative criteria: novelty, non-obviousness and the utility. The problem research and unique features of the solution can be incremental, as I given the example of memory storage device. And what aspect of that invention should be protected, that is also you need to see, because sometimes only a process can be, a novel process is patentable. Sometimes a product out of that process also have some novel feature. So you should look into that invention and assess that what are the aspects we can protect for, we can claim for protection. And of course, we need to give full disclosure for reproducibility. So this is a patent filing process. The application may be a provisional one or a complete specification. Provisional one only may or may not contain the claims. It is only the idea, the concept and some preliminary findings you can disclose that. Mostly whenever the inventors are getting positive results, but they need some time to complete those experiments, or they are looking for some fund. So and maybe there are some publication is outing. So we are actually facilitating provisional application. Complete specification, as the name implies, it includes all the experiment details, all the claims and all these things. And you have to file the first domestic application. Then if you wish to, you can file international application too. And there are some international treaty like Patent Corporation Treaty as administered by WIPO, World Intellectual Property Organization. It is a platform of filing single application for more than one country. Before filing any patent application, we should always ensure our novelty by doing prior art search. In fact, prior art search you can any inventor should do before before initiating their R&D work. What are already available in this particular zone? Just to avoid, I have already mentioned, just to avoid reinventing the same thing. And of course, before filing the application, to establish a novelty, because R&D work needs some time. Within this time, if somebody has filed the same thing, same technical aspect, so you may lose your novelty. And of course, when you are actually manufacturing, you're producing your invention, you need to check whether it is a part of, if it is an incremental invention especially, whether it is a part of a big product, big technical aspect, so that the main patent can be held by any other, and you need to check that is freedom to operate, whether I am free to operate, whether there is any valid patent, then we can approach that parent owner of that parent patent, we can go together or not, it's like that. So for searching prior art, we have patent databases, some of are free, like Google Patent Search, then all the National Patent Office websites like USPTO, SpaceNet, IPO, and even WIPO is providing a free database, patent database for prior art searching. And some of them are paid databases like Crystal Database, Darwin Invention, and there are so many also. This is a flow chart of filing patent in India. So as I mentioned, there are two types of application mostly. One is provisional and one is complete specification. You have to keep in mind that if you filing a provisional specification, within 12 months time you have to file the complete specification. Otherwise, it get abandoned. So after filing the complete specification, it will getting published by within 18 months of first filing date, and on requesting of examination of that patent application. So examiner will examine the patent application, and he will raise first examination report, that is called FER. If he finds any objection related to that application, so he will raise that objection in the FER. You need to respond to that legally, and on requesting re-examination, he will re-examine that. If he is satisfied with that, your argument, your defense, he can offer you a grant, or the patent application get rejected. And in the first sort of examination, if he doesn't have any objection in claim part, in specification, all the criteria of filing an application, if it is met properly, so the examiner can grant the patent application, and after granting, it will again published in their official journal, and it is open for post-grant opposition for 12 months. Anybody can oppose your application, your grant patent even, and you need to again defend that whether your argument are valid or not. That will be judged by the examiner himself, and if it is if the objection overruled, your patent will get validity, and if it is sustained, then your patent can be revoked also. Here are the just have a glance of few important forms. Like form 1 is for application for grant, when you are filing your application for the first time, and it is to be signed by the inventors themselves. They are assigning their institutes or any industry wherever they are related to, so to file this application. This form 2 is a complete or provisional specification, all the experimental details, all the claims it includes here. And there are form 3, which actually gives a declaration for any foreign filing things, whether you have filed any related for international patents or not. You have to disclose this to the National Patent Office also. Then form 27, it is also very important. After filing the patent application, every year 31st March, you have to file a statement of working related to that patent application, whether you have commercialized that patent or whether it is still not commercialized. Then what are the efforts you have taken to commercialize these things. You need to mention all these things to the government, because you need to know that one part of patent protection is that society should also get benefited with the new technology. So if you are not taking any efforts to commercialize that, you are also losing the money, even the society also losing any benefit out of that new technology. So form 26 is the authorization of patent agent or patent attorney to file on behalf of you or your inventor. This is how the patent grant certificate looks like. Some of our Indian patents certificate, and one is for USPTO grant certificate. Now let us move to copyright. This is the exclusive right given by the law for a certain period of time, of course, and for any creative expression. This is of two types. One is for economic right and one is the moral right. It is actually the bundle of rights, so it is enable the author to reproduce, adapt, broadcast, recording, translation. Even the performance and related rights also come under copyright these days. So if you are filing any domestic application, your work will be actually protected throughout the world under some Berne Convention. It is an international treaty. No need to go and file individual countries, just like patent. Here are the term of copyright for any literary, dramatic, musical and artistic work. It is the author's life plus 60 years, and for any publication, if it is a posthumous publication also, it is a 60 years from a date of first publication. There are some exception of copyright, they are called fair use. If I am using some copyrightable work for my personal use, I have made only a single copy, just to read, it is not that I am violating the copyrightable work. Or else I am using it for only teaching purpose. I am not making money out of that. So that is called fair use. Here are the examples of copyrightable works, like all these music composition, photography, literary dramatic works, cinematographic film, animation, videos, graphic drawing, or computer software, all comes under copyright. Here are also few examples only. This is a public license that is offered by the author of this copyrightable work for free distribution, free right to share, use or build upon work on otherwise copyrightable work. As Professor Kannan has mentioned that Talk to Teacher spoken tutorial software and program, this is actually made available by under Creative Commons license to freely distribute and use by others. Similarly, we have ChemPlay also. It is a kit of text and concepts in chemistry. It is also made available by the inventors, by the authors to online teaching for chemistry. Let's move to industrial design. Any aesthetic appearance of an article is protected by Design Act. It is for the term of the protection is 10 years, wherever it can be extended up to 15 years by renewal. So mind it, if you just only the expression of the design, if you just design some ornaments, the design can be copyrighted. And that if when it is applicable to the ornaments, when it is applicable to some maybe that watch also, with that article, the design right get protected. Now, what are the trademarks? It is any sign, logo, mark, or any shape. Similarly, as in case of patent, there are database for finding the prior arts, what are existing designs for this particular thing, that is also available. So, this is any sign, mark, logo, any symbol, any name, any shape, any color concept that is actually used to make some identity for a particular product, to establish a brand. That is actually protected by trademarks. It is initially registered for 10 years and that term is perpetual provided you have renewed it every 10 years. So, just like example of McDonald, whenever you write in YOLO, the way it is writing the aim and I am loving it, the slogan, it is a trademark. And the MasterCard, all this logo of Tata, Skypeak, all this actually trademark thing, this is actually distinguishable mark. And even the Johnson & Johnson have the Oleo mark, that's fragrance of baby products. So, geographical indications are offered for some agricultural, natural or manufacturing goods. The quality of that particular product is attributable to the particular climatic condition for a geographical location. For India, the first GI registered under the name of Darjeeling tea. So, it is a symbol, of course, it is a trademark symbol of Darjeeling tea, and it is not that you have you have grown tea in outside Darjeeling and you are claiming that it is Darjeeling tea. No, it is not possible. And similarly, we have Odisha Ikot from Sambalpur, Odisha. There are many more, means Madhuban painting from Bihar, some Agra Petha, some Alfonso mangoes. These are all comes under geographical indication, and it is not offered to any particular individual person. It is offered to some governing body who are actually maintaining, growing, in helping the farmers, the body who are actually working in this particular field. And without getting authorization, you cannot produce some Ikat, Odissi cloth from outside Sambalpur. So, you need to get the permission from that governing body. What are the IPR coverage in any invention? It may only contain only a single inventive concept, or it may be a basket of IP. Like in the classic example is Coca-Cola, the way it is written in white in a red background, it is under trademark. The can opening mechanism of Coca-Cola can is patented, and all the advertisement and creative depiction is under copyright. The formula, it is not under patentable invention, of course, because it is only the admixture of the some sweetener in carbonated soft drinks. So the formula is heavily guarded by the trade secret here. In case of IIT Bombay also, we have many times encountered with such invention which have more than one inventive concept. Like if the inventors have developed some device, and if it is functioning something technically, it is solving some technical problem, then the technical features can be protected by patents, and the how it works, the functionality is actually can be covered by the manual of these things, and it is that manual is covered by copyright. So now let us move, means we have seen that what are the intellectual properties, what are the rights related to it. Now let us move what are the, means how we can manage our IPs, because when we have grow with number of IPs, we need to manage them. So in academic perspective, actually I am just giving you some guidelines what we are following in IIT Bombay, what are the standard procedures for managing IPs. Like in academic activities mostly involve the teaching, all the lectures, the seminars, the presentation, all comes under copyrightable work that I have just mentioned. If you are involving in some research works that may develop to some patented inventions, so you need to be cautious about that. When you are involving in some outreach activities like IIT Bombay is also doing under continuous education program, so we also must aware what we need to disclose to them, what we cannot disclose them unless I protect my IP. So we need to be careful about that. When you are doing some collaboration for R&D work with some industries, then also we need to be cautious about, without signing any non-disclosure agreement, we should not give the disclosure of our patent, of my invention, my IP to the industry also. And if we can move further, so we can license or transfer our protected IP, and we can promote our the startup companies, entrepreneurship, like for the young inventors to take it up further for commercialization of the IPs. So our main motto to derive the maximum benefit out of our IP, whatever we have developed, whatever we have taken care of, means since the inception, the protection, filing, all involve maintenance of that IP, all involves cost. Nothing comes free, and it is heavily costed to these days. For getting only filing Indian application, it takes around close to 1 lakh rupees to filing only Indian application. Maintenance for 20 years, and for responding any office actions, for responding your objections and all these things needs additional money. So all these things we need to keep in mind, so that our invention should not be copied and all these things. So before it gets published, before it comes into the public domain, we should seek for appropriate protection, and we need to take decision when to commercialize those IPs, because some technologies are changing very fastly, like in case of mobile software technology. It is changing within a year, maybe the lifespan is only for 6 months. So you need to be very proactive in those days. So we need the process and are needed for IP creation, protection, utilization, deployment and all these things. So first of all, you need to grow awareness. How to develop IP means what are the technology you should work for, means that has direct market availability or commercialization ability. When and where we need to protect our IP, and how to commercialize those IP. For all these things, we need some institute level policy. Yes? No, it is only you are talking about the government fees. But mostly the patent applications are drafted by some legal experts who are the patent attorneys. So they will. But sir, it is very unlikely, but because we are the technical background people. So our patent application is actually legally explained all the technical things. It is not only the technical, it is not like writing the publication. It has many legal aspects to be covered. Examination and the response to any objection, of course it needs file. Even I am telling for maintaining your IP for 20 years, for any patent to maintain it costs more than a lakh, because after 14 years it takes every year 45,000 to maintain your IP, maintain your patent, sir. So yeah, so and we need to formulate some institution level IP policy, and we need to support to facilitate the IP filing and protection, and any legal supports if it is needed for commercialization activity, and of course the filing things also. And we need a framework for how to commercialize, whether we need to proactively approach industry, or some industry will do some collaborative work and all these things. And we need to incentivize our inventors also, because they also get motivated with these inventors incentives. So the IP policy must have the must define the ownership of the IP. As in our case, we can give example that any IP that is developed in IIT Bombay by any faculty or student, that is actually owned by IIT Bombay, with some exceptions. If there is some thesis, your MTech student's thesis or PhD thesis is there, the copyright of that thesis is ownership of that copyright is actually going to students and the guide, means the professor. Institution does not own that copyright of the thesis. But if that thesis includes some technical inventions, that actually that technical invention, the ownership of that technical inventions, means if it is a patentable things, then the ownership of that patent will be taken care by the IIT Bombay only. So here we are actually, IRCC is actually coordinating all these things. We are actually facilitating to disclose the invention. We have some uniform form like things, invention disclosure form, where any inventor, whether he is a student or faculty or a project staff which have the which are employed to our IIT Bombay, so they can fill this disclosure form and submit to us. It is available to our online portal. Then we review and assess those inventions, whether it is meeting the criteria, and we are then proceeding for IPR filings. Even actually for Indian filing, all the and for maintenance for first 10 years, IITB is taking care for all the cost. And for next, of course, the next things actually, we ask our inventors to share the cost, and of course for international filing also, we ask our inventors to share the cost. Then for technological commercialization also, we have some framework for doing these things. And of course that revenue sharing, as I have mentioned, we have actually, whenever we commercialize any technology, the 70% whatever we earn as a revenue from the commercialization of that IP, 70% goes back to the inventor. These are only guidelines. You may frame your own IP policy, own framework applicable to your institutes. So we actually allow self-assessment of patentability to the inventors in the first instance. Then you allow them to facilitate the prior art search databases, which are actually paid databases which cover all the databases across the world. Then we have panel of IP attorneys who can draft the legal application for patent applications for you. And we always ask our inventors before get it published or before make any public presentation of your invention, first seek your protection. And sometimes when students submit their thesis, we proactively without even having the invention disclosure form, we just assess the thesis itself, and if we find if had some technical aspects of that can be patentable, then we go back to the relevant respective faculties for further getting in remarks from them. And every year out of maybe more than 1,000 like theses, we found at least 4 or 5 such patented inventions. So as I have mentioned that for our protection and initial maintenance for first 10 years, we are taking all the cost. So, and after filing also, you need to regularly audit your IP asset. Means if your technology is in the maturity level in the technology life cycle, you need to be aware when you need to commercially, you need to introduce your thing into the market. And of course, we do some proactive dissemination of your inventions for licensing, like we do regular advertisements, brochures, we need and websites. We periodically display our licensable technology, and we talk to different industry for further collaboration in R&D. We promote entrepreneurship under SIGN, that is a Society for Innovation and Entrepreneurship. This helps to actually channelize all the government funding to the young inventors, and we provide all the legal support for agreement, MOUs to collaborate further and to license the technology to the industry. And of course, it is the same way we actually promote this awareness, we promote the entrepreneurship courses, and we do regular workshops, seminars to promote the awareness of IP and its protection among the students, faculties, and all our project staff. We always in continuous interaction. We do the department tour also to just simply make them aware, make them just be aware of the importance of IP. We help in mostly the student-led inventions too. So just conclusive remarks is that as I have said, we need to understand the implications of IP and the rights related to it. We need to balance in education, research, and the translational efforts. And of course, we need to encourage the young inventors and facilitate all the process, the legal processes, of course, because all these inventors are from technical background, as I just said. So you need to support them, you need to encourage them, and we need to move forward for technical and meaningful R&D so that we can get more, build our IP asset and get commercialized that. So.
So, I'd like to thank Ms.Sanjana for taking time out of her study busy schedule and talking about IP policy of IIT. As you would realize that we have a very well established IP cell, which actually the head of the IP cell is traveling right now. She's abroad. She could come. So we have a well established IP cell. We have IP lawyers, and we provide all support, legal support, also financial support to help students and faculty to commercialize. So thanks again.
How many patents I have?
How many patents?
Many patents I have.
So I have some small announcement after that.
It is, the patent application is around 750 and so on. It is increasing every day. And patent applications. Granted is around 250, more than 250. Because it takes more than 6 to 7 years to get a examination, first examination report of on your application.